Hi, I'm attorney Ryan Alexander. If you've been sued and served a summons by a process server, you probably have a few questions about what you can do to defend yourself. The first thing you'll need to know is what county you're being sued in. It should be on the caption of the summons or on the first page in the caption of the lawsuit itself. You will probably need an attorney in that county or in that state at least to defend yourself. Now, the first question everyone has is based on the language of the summons or on the demand letter of a creditor. For example, credit cards. They always say that they're going to garnish your bank account or your wages. Can they garnish your bank account and wages? Only after they've sued you and only after they've gotten a judgment. So I usually tell people no. They can't garnish your wages and they can't get anything from your bank accounts or take or auction any of your property until they've sued you, gotten a judgment, and then gotten a writ of execution or the right to execute on that judgment from the judge. That process takes a couple of months, even if they're moving quickly, and often in credit card lawsuits can take 6 months or more. So there is no immediate threat of them garnishing your wages or your bank account within the next 30 days. However, they can file for an emergency to attach your possessions so that you don't sell or transfer anything, but that would be served to you as a special set of paperwork that you would get from the court. It would be basically a court order preventing you from that. It's not typical in a regular lawsuit to see that kind of a motion preventing you or an order preventing you from disposing of any of your assets. It would probably be more common in a tax, family court situation or in a lawsuit between business partners who know each other. Now, what can you do? So you've been served a lawsuit. First choice is you can choose to defend the lawsuit. Now, you can either pay for an attorney yourself or use your insurance company, if you have insurance coverage, to pay for the attorney. Most civil attorneys charge at least $200 to $300 per hour, so you are looking at a significant expense. I usually tell people that a lawsuit will cost you, a small lawsuit will at least cost you about $25,000 to $40,000, and a significant lawsuit in district court or in federal court will probably cost you about $50,000 per trial day, meaning if you have a 2-day trial, you need to budget at least $100,000 to pay for the attorney's fees for that. So it's prohibitively expensive for most people to defend a civil lawsuit out of their own pocket. Most people will need insurance coverage to afford to defend a lawsuit. So what can you do if you can't afford the attorney? So if you can't afford the civil attorney, you have several other options. One would be to settle the lawsuit for whatever money you can afford to pay the other side. And that would be a realistic look at what you can afford and what is the total potential cost of the lawsuit to you. And at times it's worth defending a lawsuit because you feel it's inappropriate or you feel that you've been wronged and that the other person's taking advantage of you. And there are times when it's worth settling a lawsuit because it's cheaper to settle the lawsuit than to fight the lawsuit. And we can take a look at what it is and what type of lawsuit if you want to come in for a free consultation. But that's always something to keep in mind, that sometimes it's worth settling a lawsuit no matter what you think of the merits of it, if it's going to turn out cheaper than fighting it the whole way. Because often a settlement will include a stipulation that you're not accepting responsibility, but you are closing the lawsuit out, which provides you with the same result. The next option would be to file for bankruptcy, and that's something that I specialize in here in Southern Nevada. And we would take a look at what you can do to file either a Chapter 7 liquidation bankruptcy to stop a creditor. For most creditors, such as credit cards or repossessed cars or houses, that would stop them dead in their tracks. Collection lawsuits usually can't go forward from there. If the suit is for taxes, or it's a tax garnishment, or if it's for child support, or if it's for something relating to fraud or criminal restitution, perhaps we can't discharge it, but we might be able to put those kinds of debts into a reorganization bankruptcy, like a Chapter 13 or Chapter 11. The other option would just be to default or just to ignore the lawsuit and let them get a judgment. If you don't have anything that they can collect, if you don't have a bank account or you don't have any assets that they can either levy or attach, then perhaps you are what we call judgment proof, and you could just let them default against you. However, I usually recommend against letting a creditor or a party just get a default judgment against you. It's usually better strategy to fight a lawsuit or to settle or to file bankruptcy. Now, if you've decided to fight for a little bit, one thing you can do is file an answer. An answer is your response to their allegations, as well as presenting any defenses you would have that would make it not your fault. They call them affirmative defenses, and it's basically telling the court it's not your fault that this happened or that they've sustained an injury because of some other factor. Either it's their fault or there is some other reason. And that is presented in what's called an affirmative defense. Now, also, you should know that a small business, if it is an LLC or a corporation or an S corporation, can't defend itself, and a person cannot go in defending their own corporation. You need to hire an attorney to represent a business entity. If you're a sole proprietorship and you just work on your own and you don't have another entity, then you can represent yourself, but otherwise you will need to hire an attorney, again, either through your insurance company or paying out of pocket, in order to defend that business entity. And a lot of people don't think about that if they have a small business such as an S corporation, that they can't just file an answer and represent their business for themselves. Either we call it either proper person or pro se debtor or pro se defendant. Now, if you file an answer, you're going to start the discovery process. That will usually last 6 months to a year, and that's the time where you're going to exchange documents with the other side. You'll be able to take depositions. You'll be deposed by the other side, which is a recorded testimony. You've probably seen it somewhere where they take a testimony in a conference room with a court reporter, and the attorney is allowed to ask you questions. Or if you are taking someone else's depositions, you're allowed to take that other person's testimony, and they're under oath. They have to answer as if they were in court. Discovery period is also the time to pick expert witnesses and create expert reports if that's necessary. Now, in a creditor lawsuit, that's usually not essential, but in lawsuits involving technical matters such as engineering or medicine or some sort of accident reconstruction, sometimes you'll need an expert involved in order to prove what happened. Unfortunately, most lawsuits are too complicated to defend yourself, and you'll need the expertise of an attorney. If you'd like to have a consultation regarding a civil lawsuit you've been served, call me, Attorney Ryan Alexander, at 702-222-3476. That's 702-222-FIRM.